All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Good afternoon. Welcome again to this afternoon session. Ms. Nauri, you may continue your opening statement, please.
Merci, Madame le Président.
Just a word on the internal functioning of the OCRB since March 2013. It must be recalled that at the beginning of the transition power, almost all FACA or police had fled, and there was a severe shortage of staff. The OCRB was understaffed, and this is precisely why the position of the transition government was that even though if the police officers came back to work, the other elements who were present were to remain as reinforcements. So this is what P1019 explains. Consequently, the people working at the OCRB under Mazangue's leadership were not Selika, but volunteers who helped him out in a situation of chaos and banditry that was constantly on the rise. P1019 also explains that the Selika returned in March, and the government had sent 500 of its Selika to the police for training and 500 to the gendarmerie, because the two structures, the police and the gendarmerie, were understaffed. So you had to support these two structures. P1019 said that this was rather an extraordinary situation, so we had to fill in the gap. And it's this situation that created a problem at the RCB, where it was impossible to determine who had the leadership. Without a reporting line, there was only individuals who carry out acts in the fight against banditry. Indeed, the rejected witness, P0234, makes it clear that you ask me who's at the head of the OCRB? It's hard to say, as it changed all the time. Over and above the structural functioning problems, it is important to note that in spite of the limited resources of the OCRB, the members at the OCRB worked with the prosecutor, and the arrests and the detentions were object of judicial control. Several arrest warrants were issued against civilians and people affiliated to the Selika. And there was a trial opened against 24 detainees, members of the Selika, who were accused of looting, destruction of property, disturbance of public order, and acts committed during the killings in Boirab on 20 August 2013. P2239 states, most of the other prisoners were all young Selika delinquents accused of burglary, drug trafficking, and theft. P0885, again a witness rejected by the prosecution, states, and I'm quoting here, the Silika who committed crimes were taken to the OCRB, and if a Silika member was arrested, he was taken to the SRI or to the OCRB. There were policemen and gendarmes on the premises. The local population would call us to report these crimes. P2563 explained in response to the question, could you give us an example of the type of offence that the Silika had to commit to be imprisoned at the OCRB, if you have any? Most of the time, they took people's things away, and they took drugs, and they drank alcohol. Conclusion. It is therefore difficult to understand on what basis the prosecution considers that the OCRB is a Silika base, where whilst it's a place where delinquents and criminals claiming to be Silika are imprisoned. This is a strange Silika base whose function is to imprison ex-Silika or looters claiming to be Silika and to subject them to normal judicial proceedings since they are presented to the public prosecutor. The prosecution, under the guise of the generic terms such as Silika, cannot get around the truth that between March and September 2013 there was no organized group capable of conducting military operations. In fact, 234, a witness rejected by prosecution, says the following. I quote, "You were asking me to elaborate on the chain of command of the Silika? That's funny. What chain of command? I must refer you to Jatodia to ask him to clarify this. There were several nationalities within the Silika, like Chadians, Sudanese, etc. Each of the commanders had their own men, and we cannot speak of deregulation of the chain of command." Since the prosecution has not succeeded in establishing the existence of an organized armed group, nor the existence of a Silika government, nor even the existence of a fully operational government, and since it appears from its evidence during the period of the charges that there is a government of national unity which is trying to function, but despite an extremely complex security context in which there are different types of banditry mixed together, any allegation of war crimes and crimes against humanity falls. Now, with regards to this legal characterization of the situation between March and September 2013. First of all, the conflict of a non-international character, CANI. The prosecution case is that this would have begun in December 2012 and continued uninterrupted throughout the period on at least till the 10th of January 2014 between what it calls Silika on the one hand and the pro-Bozize reconstituted as the Anti-Balaka on the other, paragraph 9 and 10 of the briefs. Once we said the prosecution case is no more convincing today than it was at the confirmation of charges hearing. The prosecution persists in making allegations that are not, in fact, even supported by its own evidence. The prosecution's position on this issue is so untenable that the prosecution's own brief demonstrates on a plain reading that until at least September 2013, any discussion on the very existence of a CANI had no factual basis. Let's take an example, paragraph 32. The prosecution states, and I'm quoting, in the 6 months that followed the ousting of Bouzize, the anti-Balaka carried out increasing number of coordinated attacks against the Selika, in brackets, and Muslim members of the civilian population in the western CAR, culminating in an assault on Bangui on the 5th of December 2013. In support of this argument, the prosecution refers to paragraph 40, 41, 48, and 49 of its submission. However, after analysis, in the foot page 4101 to 1 of the brief, however, after analysis, it appears that none of these paragraphs refer to the existence of alleged coordinated attacks against the Selika in the first 6 months following Bouzize's ousting, that is between 24th March and September 2013. Paragraph 40. Paragraph 40 of the prosecution's brief states that initially, until the fall of Bangui on 24th of March 2013, the FACA were forced to defend themselves against the advance of the Selika. This paragraph clearly refers to the period before 24th March 2013. This does not in any way support the prosecution's claim. Paragraph 41 of the prosecution's trial brief states that, and I'm quoting, subsequently the reorganization of the pro-Bouzize forces, including some elements of the FACA who remained to Bouzize, enabled them to carry out coordinated attacks in the second half of 2013. In particular, they launched a rocket at the National Assembly building in Bangui with the aim of disrupting Jatodia's second inauguration ceremony that was held on the 18th of August 2013. Already we note the jump in time of the prosecution that goes directly to the second half of the 2013 without giving the slightest information on the period from March to August 2013. Above all, it is easy to see from the brief that, in fact, the only example the prosecution has before September 2013 is the alleged incident against the National Assembly in August 2013. An incident on which the prosecution does not provide any evidence from an independent investigation on its perpetrators in its organization or in its course. An incident for which it is clear from the prosecution's evidence that it actually involved some former FACA who allegedly did not leave Bangui in March 2013 but hid in Boyrab. An obviously isolated incident that cannot be taken as evidence of the existence of an armed conflict, and certainly not between March and September 2013. Paragraph 48 of the prosecution states that from September 2013, the anti-Balaka groups began to engage in more intense fighting against the Selika in the western CAR. We are now, in the words of the prosecution itself in September 2013, still nothing about the period March to September. Finally, paragraph 49, the prosecution states, and I quoting, the 5th December attack on Bangui was not an immediate success, but it triggered weeks of escalating violence. Again, there's still nothing, no information on the period from March to September 2013. Thus, the prosecution's own brief does not appear to support the prosecution's claim that anything relevant happened between March and September 2013. In the end, the prosecutor himself limits my own assertions, the period during which it is impossible, simply impossible, to speak factually of Kani. The only example of an attack that he attributes to the Sri-Lanka coalition is the seizure of Bangui in 2013, which we've already seen was not in fact organized, and then nothing more. Then the prosecution's evidence on the anti-Balaka only mentions events that could have any relevance from September 2013 onwards. Surely well aware of the weakness of its arguments and the complete disconnection of its position from the reality that prevailed on the ground, the prosecution attempts to evacuate the difficulty of the temporal scope of the armed conflict right from the first paragraph of its brief, as it begins by explaining why the report of the UN International Commission of Inquiry on the Central African Republic, having concluded there was no Kani between March and September 2013, would be wrong. In this report, the UN experts, after a careful factual analysis of the situation, found that, and I'm quoting, the level of hostilities between March 2013 and early December did not reach the level required to conclude that an armed conflict existed. The prosecution presents this report as if it was an isolated document or a position, forgetting to point out that the legal conclusion of the Commission of Inquiry is based, above all, on an analysis of the ICRC statements. Indeed, the UN report highlights a change of the legal characterization of the situation in CAR between 2011 and 2013. In 2012, a Kani had been identified, whereas in 2013, the ICRC does not identify any armed conflict and now refers to the presence in CAR not of combatants but of weapon bearers, whom the ICRC calls on to respect their human rights obligations, thus not mentioning the existence of obligation in terms of international humanitarian law, which would have been the case if there were a Kani. The prosecution quotes the report as saying, future analysis based on more detailed accounts of all the many events that occurred in this time frame may lead to a different conclusion. Footnote 32, paragraph 13 of the prosecution brief. But the reality is that no one has changed their mind. And this is normal because this is not reality. The prosecution today does not follow the UN advice and still tries in its brief to assert that there was an Kani in 2013, which is completely disconnected from the reality and from facts. And nobody, the UN, the ICRC, the NGOs, and neither international human rights, humanitarian law specialists support. The prosecution fails to indicate today that its position, to the best of defense's knowledge, is not supported by any source that it has been able to identify. Thus, in addition to the UN report, the ICRC report contradicts the prosecution's position. Professors Casey, Malsen, and Haynes write in 2018 in I'm going to speak in English because the title is in English. So they write in English.
The conduct of hostilities under the law of armed conflict.
End of quote. That there are strong doubts in that an armed conflict existed in CAR after March 2013. So this is 2018 we're talking about. Again in 2018, Tillman Rodenhauser in Organizing Rebellion, end of quote, in 2018 echoes the findings of the UN Commission of Inquiry. The annual war report, the 2013 annual war report published by Oxford University, one of the leading authorities on the subject, states that the armed violence in CAR since April 13 does not constitute armed conflict under international law, as the groups involved did not meet the criterion of organization. Anissa Bilal, who had been a legal advisor to the Office of the United Nations High Commissioner for Human Rights, wrote in 2014 that with the effective disappearance of one of the two parties to the conflict, international humanitarian law ceased to apply in CAR as of 25th of March. The Central African Republic, from conflict to chaos, back again. The IPES report, to which the prosecutor refers to several times in his submission, confirmed that around August 2013, the first of these groups reformed, attacking the Selika in and around Busangwa and Buka in September. The 2014 UN Commission of Inquiry report states that, and I'm quoting, the first traces of the anti-Balaka were seen in the town of Busangwa in September 2013, but it was only on the 5th of December 2013, when they attacked Bangui, that the anti-Balaka demonstrated that they had the capacity to carry out a military attack. Page 286 of the report. Lastly, the UN mapping report, which is a 400-page report long, dating to 2017, drafted by the MINUSCA, the UN Development Programme, the Office of the High Commissioner for Human Rights, and the Office of the Special Representative of the Secretary General on Sexual Violence and Conflict, covering the period from 2003 to 2015, consistently finds no significant activity by the so-called anti-Balaka before September 2013. And more importantly, this report concludes that between March and September 2013, the Selika did not face coordinated military opposition, making the existence of an armed conflict during this period unlikely. Exhibit Keshkar OTP 2055, 1987, page 2232. Where are these elements addressed in the prosecution's brief? Nowhere. The prosecution insists on only criticizing the 2014 UN Commission of Inquiry report and pretends that no one has been interested in this issue ever since, which completes the prosecution's denial of reality on this issue. One final point, Your Honours. In the trial brief, the prosecution asserts that, and I'm quoting, at the time of the events, side had knowledge of the factual circumstances establishing the existence of an armed conflict, paragraph 51 of the trial brief. On this specific point, it should be recalled that the knowledge within the meaning of the Article 30 of the staff regulations must be determined at the time of the facts. At the time of the facts. In other words, in order for the mental element, the intangible element that is knowledge to be established, the person concerned must necessarily have been aware of the facts or the situation at the time of their commission or existence. Therefore, in order to establish Mr. Said's knowledge of the factual circumstances establishing the alleged existence of an armed conflict, it must be demonstrated that Mr. Said had the knowledge of them during the period concerned by the alleged armed conflict. However, in 2013, as we've just demonstrated, the existence of an armed conflict of a non-international nature in CAR was not at all established. On the contrary, the various reports showed that the existence of an armed conflict was widely discussed, even refuted at the time of the events. This position has persisted for a long time, to the extent that to this day, the prosecution is still unable to present any evidence that anyone, UN, NGOs, international humanitarian law specialists, consider that there was a Kani in 2030 in the CAR. So how could Mr. Said have had the knowledge of an alleged existence of a non-international armed conflict when organizations like the UN or the ICRC, whose researchers are constantly working on the subject, themselves did not know about it? Thus, it is obvious that Mr. Said could not have the knowledge of the factual circumstances establishing the existence of an armed conflict, as the prosecution claims. In any event, the prosecution, which moreover dispatches the subject by devoting only one paragraph to it, does not demonstrate in any way the knowledge that Mr. Said could have had on the alleged situation of the armed conflict at that time of the events in 2013. The prosecution asserts that, and I'm quoting, throughout this period, the activities of the pro-Bouzize and anti-Balaka forces and the crass exchange of fire was widely reported in the press articles and radio broadcast to which Said had access, paragraph 51 of the trial brief. Beyond the fact that the prosecution's argument seems to suggest that the prosecution considers that the content of a press article a source of limited probative value in international criminal proceedings, should be taken as face value by its reader, which raises questions on the prosecution's general approach to its evidence. An analysis of the footnote references shows, once again, that the press articles referred to do not support the prosecution's assertions, as the prosecution refers to footnotes to press articles and radio broadcasts which are either irrelevant or, again, dated from the second half of 2013.
À titre d'exemple, l'une des pièces. Car OTP
Car OTP 201-4641. This is an interview of François Bouzizet by France in August 2013. contrary to the affirmations of the prosecution. It's mentioned in this article that François Bozizé, and I quote, knows that for the moment he doesn't benefit and doesn't enjoy any base in the region. This is page 4147, which contradicts the idea of any organization of the anti-Balaka. Furthermore, François Bozizé, when asked the question, and I quote, "Do you think you'll take up arms, launch a guerrilla?" And the answer, "I don't forbid myself anything," but that is not actuality. It's not something of today. So it's difficult in these conditions, in reading this article, that there's an awareness of the existence of a non-international armed conflict in the Central African Republic at that time. The circle has gone full round. Mrs. President, Your Honours, regardless of the angle you take, and despite all efforts, the prosecution has nothing to submit to you. They cannot give you anything during the trial which will show you the existence of a non-international armed conflict in the Central African Republic between March and September 2013. And now we have the crimes against humanity, and these 2 points will be given to Professor Jacobs to finish our opening statements. Thank you, Your Honours.
Thank you very much, Ms. Nawe. Mr. Jacobs, please.
Madame la Présidente,
Your Honours, as we've just shown you, the prosecution is incapable of showing the existence of the contextual elements of war crimes. Principally because it's incapable of proving that what they call the Seleka could make up a group that's sufficiently structured, organized, and hierarchical within Article 8 of the statute. The arguments put forward by the prosecution dealing with crimes against humanity fail for precisely the same reasons. In fact, the prosecution needs to prove, in accordance with Article 7.2 of the Roman Statute, the existence of a policy or a state of organization. And we will see this throughout the process, that the prosecution will never be able to show or prove this. This lack, this flaw is in the narrative and is also has no probative value. The flaws of the prosecution in its narrative and also in the area of the evidence, and I'm going to look at these 2 points right now. Firstly, as regards the narrative, as we have already shown you, the Seleka never existed as a homogeneous entity, neither before arrival in Bangui, neither after its arrival there. At that time, the heterogeneous coalition and not organized coalition which entered in Bangui with the sole aim to make the anti-democratic government of President Bozizé collapse, was so fragmented and dissolute that they had little groups that were permanently struggling and fighting within each other, but they met in order to get the pecuniary fruits by capturing Bangui. As previously mentioned, but this is a key question, and I come back to it, the United Nations sums up this atmosphere perfectly well, this atmosphere of generalized chaos. The United Nations said the Seleka was a composition of blocks, looking for individual interests, trying to find personal resources rather than a government with a clear political agenda. The Seleka remained a non-homogeneous unit and was not able to take, they only took instructions, the soldiers only took instructions from their own commanders. The mission adds that they could not obtain a list of deployment which broke down the functioning and structure of the Seleka and the establishment of a command line. In these circumstances, we are forced to say that a policy that was decided by the Seleka does not make much sense. And that one of the realities that prevails at that time, all the affirmations of the prosecution relating to this policy assumes a completely different meaning. We should note here, and we will do this during the trial, that the reality that the prosecution refuses to see is this. The events which the prosecution talks about, and as they are established, relate to common criminality, which is seen through looting, through a framework of complete disorganization and generalized anarchy. Confronted to the fact that this looting constituted the essential of the activities of individuals who could not be controlled, and that the engine of these individuals was a loss of gain and not a general policy, the prosecution denies the reality. And rather than drawing the consequences, logical consequences, and recognize the common criminal character of what is happening, the prosecution insists, regardless of the cost of this, to introduce this reality in its imagination of a general and structured policy. How? By trying to change these lootings practices which are not targeted in the Statute of Rome by making it a criminal action under criminal law, which falls under the framework of Article 7. The prosecution wants to change at all costs this file, which shows the common criminality in the Central African Republic, and make this an international crime file. But that is not the function of the ICC to look into the common law criminality. The events of Boerab during 2013, which prosecution has talked, is within this logicality of pillaging, looting, and ordinary criminality. What becomes apparent from the analysis of the prosecution is the looting for individual gain and random acts of violence. Each witness describes how looters took goods, mattresses, television, chairs, tables, fridges, The fact that these lootings were for personal gain is the core of the activity for the individuals in question and shows the need to satisfy for personal gains without any political considerations or instructions. On the contrary, the evidence of the prosecution shows that these persons didn't obey orders, even those coming from what the prosecution call the leaders. For example, P0851 says, and I quote, when I arrived near me, the Seleka pointed their weapons to us and asked who we were. Niadin Adam introduced himself, but they didn't stop looting. Noureddin Adam told them, stop looting. Noureddin said, don't loot this dwelling. The Seleka elements who were looting the dwelling seemed to belong to another faction of the Seleka group. This movement was in fact very dispersed. End of quote. This witness is illuminating, and that perhaps explains why the prosecution is not going to call upon this witness. Another example which reflects this reality, P1970 says about the Seleka that he was killed by another Seleka where there was an argument about the objects looted. End of quote. Here you can see the disorganized and chaotic character of these actions, because the Seleka killed each other for objects that had been looted. Where is the policy and the organization in all of this? The prosecution refuses to see the reality of the common crimes which was rampant and does not convince us of the existence of a so-called policy aiming or targeting the supporters of President Bouzize. Within the framework of this discussion, as regards the contextual elements, the prosecution states that the persons who were taken as target by the so-called Seleka, that's to say the Christians, the ethnic Baya, Manda and Manja, the inhabitants of certain areas of Bangui or who carried out certain professions who were regarded as favorable to François Bouzize, such as the members of FACA, the members of the former presidential guard of François Bouzize, and people who were close to him, and finally, officers who were employed by the government of François Bouzize. Yet, reading the trial of the prosecution, the brief of the prosecution, we notice that there are a methodological bias, which means that in reality the prosecution will never be able to show the policies which will aim at these people that have been mentioned. Firstly, the approach of the prosecution has a bias in the selection of examples, which has a bias which is presupposed on the existence of a political plan. The prosecution says as an acquisition that there is a policy and chooses its examples accordingly. In fact, because the prosecution presupposes that there is a policy, it only looks for examples relating to individuals who they see as victims of that policy and uses this to validate, to prove that this policy does exist. Once that the existence of the policy is presupposed, the prosecution chooses victims who validate this. They choose Christians, Baya, etc., and only concentrate on these victims, look at only those victims in the group, and you can see the problem in this. The problem here is that if they proceed in this way, the prosecution doesn't take into account anything that isn't in line with their narrative. Furthermore, during this process, the prosecution doesn't give any numbers on the police activities of Bangui during this period. Without this information, we cannot show that the incidents which are alleged are isolated or that they are part of an overall policy. In the same vein, the prosecution has not made any effort during their investigation to obtain any figures on the inmates in the ORCB during the entire period covered by these charges. There again, without figures of the inmates, how can we start to say that there was a plan which suffered from these incidents alleged? How do we know that these aren't isolated? What is the factual basis for this? And this is something that the prosecution hasn't dealt with. I state this is an original problem. This is a starting basis which has not been addressed by the prosecution. So as from today, given the prosecution's submissions, this problem cannot be resolved. We do not have figures. We do not have useful data. So it's impossible on this basis to affirm that there was a general policy. Furthermore, as we said previously, we have witnesses who say that the inmates of the ORCB were made up of common criminals and people who went to the Seleka because they were subject of criminality and looting.
Les failles de l'approche de
The flaws are not only in method but also in fact. If you put together all the population which, according to the prosecution, were targeted, then they would cover the majority of the Central African population as a whole. Because 90% are Christian in Kar, and the three ethnic groups mentioned by the prosecution in its brief make up 75% of the Central African population. In other words, statistically, if a person dies, regardless of the reason why, it is likely that he is one part of the groups which the prosecution mentions. To be clear, the alleged victims would be part of this group. Statistically, doesn't prove anything on the existence of a policy held within that group. The final method used in the arguments put forward by the prosecution is the logic that is used by them. In fact, even if you have to accept for the need of the discussion some of the witness statements who confirm that during the looting, some looters talked about their allegiance to François Bouzizé, it still doesn't prove that there was a general overall policy. It is the prosecution to prove that these isolated incidents are not the fruit of animosity of a personal nature, and that it cannot be accepted like that. Within a legal trial from the prosecution, which means that the burden of proof is on them to prove their case. Once again, there is a lack of logic, because in each case, it is not personal animosity that might be the one that is fueling the looter. The only place in the brief where you could see that the prosecution has given evidence that would prove some sort of existence of a policy is the section that says that the Seleka publicly announced its policy, where it stated that it would use as targets supporters of Bozize. Paragraph 91. Now let's move on to the generic term Seleka. What do we notice when reading the examples given by the prosecution at the bottom of the page and in its text? There again, these are isolated cases and individual cases of witnesses which have been reproached as being supporters of Bozize. And once again, this logic doesn't show that there's a general policy. Again, within this framework, in paragraph 93, it says Adam and Dojete also made radio broadcasts where they mentioned Boyrab and the residents in such a way that gave rise to panic. As regards the imminent attack, this is paragraph 93 of the brief. When reading through this, the prosecution, one would suppose that it would give you the speeches so that you could read through the speeches to fully understand them, but that's not the case. The prosecution refers to the witness, doesn't refer to one single witness who heard any discussions or broadcasts on the radio and gives their views on the discussion that took place on the broadcast.
Un discours, c'est un...
A speech. So the interpreter corrects, it's not a discussion, but a speech. So they waited that the prosecution would put before the chamber these speeches so that we could analyze them and discuss them, but there is no witness to do so. And so we remain with this perception, which is very subjective on the behalf of the witness. Where are these broadcasts? We don't know. Where are all these speeches? Public speeches, which the prosecution talks about. We can't find them anywhere in the file. How can the prosecution make such a generic allegation on the existence of a public broadcast on the basis of a single witness without doing anything to verify what the witness was saying? This example is a perfect illustration of the weak evidence in this file, and this is the consequence of a flawed method used, which means that they consistently believed what the witness was saying, took his word for it.
Pardon, juste pour être clair que
I'm going to repeat the last sentence for the sake of clarification. This example which I've just given is a perfect illustration that the weak evidence in this case is the reality of the consequence of a flawed investigation where the prosecution has believed the prosecution and took him at his word without systematically examining it.
donc l'on peut constater que
So we can actually see that the prosecution is not providing any proof to support his statements, and he hasn't actually demonstrated the existence of any policy. The flawed nature of the statement is rather, when you analyze the proof provided by the prosecution, when you analyze the proof or the evidence provided by the prosecution to support the contextual elements of crime against humanity, we feel very quickly that the prosecution is only contenting with lesser evidence in its case. And yet, the prosecution is unable to demonstrate contextual information that constitute the charges. And it's not because it's contextual elements that the prosecution can be vague or less specific or draw on elements of a lesser value. In this context, it is striking to observe that the prosecution is referring in this party to certain NGO reports, FIDH, IPIS, UN documents, Human Rights Watch, that have been evoked about a dozen of times. However, an NGO or a UN report necessarily has less probative value, since these reports are generally based on anonymous hearsay and hence cannot be verified by the parties or by the chamber. And these are reports that cannot logically provide any basis for corroboration. Indeed, how can the prosecution claim any corroboration when it is unable to determine whether it has at least two different sources? Furthermore, the prosecution relies here, as it has throughout the case, heavily and anonymously relied on hearsay for each of the incidents discussed. I talked about the minibus incident on 8 witnesses based exclusively on hearsay, but the same can be demonstrated for the other incidents provided by the prosecution to support the context, to support the contextual elements. Lastly, most of the witness on which the prosecution is relying for contextual elements are not called to bear witness. For instance, with regards to the incidents related to the 7th arrondissement in Bangui, the prosecution relies on 6 witnesses, and only one has been called in here for the hearing. And this approach is rather surprising because the only witness, PO 302, says that he remained in his place during the time of the alleged events. At this stage of demonstration, Your Honours, it is clearly evident that the two pillars on which the prosecution relies completely collapse. The allegations of crimes against war and crimes against humanity, the prosecution cannot demonstrate the existence of an armed conflict of international nature or any organized group. So in these circumstances, there's a domino effect, and it is normal that the accusation of the against Mr. Said made by the prosecution collapse. And especially, we can note the absence of any demonstration at all on the existence of a so-called common plan, which is central on the mode of liability for on Article 25(3)(a). Thus, the prosecution asserts that in paragraph 329 in its brief, this agreement can be inferred from the commission of the crimes from the actions of the co-perpetrators, in particular of Said, and from the subsequent conduct of co-perpetrators at SIDA, in particular Adam Tahir and Debush, namely the continuation of the same pattern of the criminal behavior, but in a more clandestine manner, covering the heads of the detainees in order to disorient them. End of quote. I've got several quick remarks to make. Firstly, by inviting the judges to deduce the so-called common plan from the alleged commissions of the crime, which is circular, and you'll agree to that, the prosecution in fact concedes that it has no direct evidence of the existence of the so-called common plan. The prosecution is reduced to asking the chamber to infer the existence of the common plan from circumstantial evidence. It is important to understand what this means. It means there is no direct evidence of a common plan implemented by several so-called Silica leaders, whilst the prosecution has been investigating the Car2 situation for 8 years and has interviewed key actors, and it has decided not to retain some of them, and has obtained the cooperation of Central African authorities. The prosecution has simply not found any evidence of what it alleges, which casts a shadow on the strength of its overall case. In relation to the approach that judges should make inferences from circumstantial evidence, it is interesting to note the position of Justice Ebo Usuji in the Ruto case, who noted that the presumption of innocence should play a role in protecting against any inferences to the detriment of the accused, especially when relying on circumstantial evidence. Secondly, the failure of the prosecution to prove anything from, for example, from paragraph 326 of the prosecution brief. and I'm quoting, it appears from the evidence that Said and Adam, Tahir, Dombusha, Yaya, Noiro, Saleh, Rakesh al-Bashar, as well as other Salika, unnamed, from the OCRB who carried out the material elements of the crimes charged with, shared a common plan or agreement to target alleged Bouzize supporters in Bangui by committing in the OCRB the crimes alleged in counts 1 to 7, and in doing so made an essential contribution to the common plan. So we can see here the circular nature of the prosecution's reasoning. Because there are alleged crimes, there's a common plan, which resulted in the commission of crimes, which constitutes a contribution to the common plan, which resulted in the commission of the crimes, which demonstrates the existence of a common plan, and so on, and henceforth, without the prosecution actually proving anything whatsoever. Thirdly, the reference to the subsequent conduct of the co-perpetrators at Sidad. Now, this reference is intended to reintroduce the arguments related to the alleged events at Sidad, even though the pretrial chamber found that the prosecution had not proved that there was a link between Mr. Said and Sidad. In the confirmation of charges hearing, the pretrial chamber concluded that after a detailed analysis of evidence presented by the prosecution, that the prosecution failed to prove any link between Mr. Said and Sidad, whether in relation to the events that allegedly took place or in relation to the more general organization of Sidad. There is absolutely no mention of Sidad in the operative part of the confirmation of charges, and no mention of liability or crimes against humanity. Logically, if there is no link between Mr. Saik and Sidad, how can the prosecution refer to Sidad in order to prove a plan of which Mr. Said was a co-perpetrator? It doesn't make sense. How can the alleged conduct of certain individuals at Sidad be of any relevance in demonstrating any alleged common plan at the OCRB, given that the pretrial chamber has clearly found that there is no link between Mr. Said and Sidad? Ultimately, the prosecution cannot demonstrate a common plan because there's simply no common plan. As we've already seen in the context of state disorganization, the OCRB carried out as best as it could its functions in fighting banditry and delinquency. We've shown that the people detained at the OCRB, and we will continue to do so, that the people detained were common criminals. And the OCRB was contributing at its level to fight looting committed by former Silika in Bangui. As for the allegations of outbursts, apart from being based on sometimes dubious and contradictory evidence, as we shall see throughout the trial, let us look at what the prosecutor's own evidence show us when outbursts against detainees are mentioned. These are isolated cases, opportunistic acts that do not follow any logic. They reveal an absolute lack of consistency or organization. They are random in nature. The alleged perpetrators of the violence, the reasons for the violence, the frequency of the violence. It is also common to find that the perpetrators' motives are purely financial in order to obtain money. It is not if you look into the entire period of charges, that nothing shows that these are part of any general policy, and it is because these are isolated acts, and they're not part of a general policy, and this is precisely why the prosecutor cannot demonstrate the existence of the elements constituting the modes of liability. Your Honours, at the confirmation hearing, I quoted a very well-known sentence by Albert Camus: to misname an object is to add to the misfortune of the world. Since the prosecution has not changed a line in its narrative, this quote even remains relevant today. Indeed, as we've seen, and we will continue to see so during the entire trial, the prosecution's case is an accumulation of statements that misname things: the Salika, the government, the politics, the armed conflict, the common crimes that occurred in Bangui, the role and functioning of the OCRB, and finally the role of Mr. Said. What is the objective of the prosecution? It's to transform the nature of events, to transform reality, to change its allegations into international crimes. To want at all costs, as the prosecution does, to fit this common law crime into the boxes of the international criminal justice, it is not to only to be of disservice to the cause and nature of the International Criminal Court, but ultimately it is more serious, is to deny reality of what the Central African Republicans have been experiencing for decades in a context of colonial and post-colonial violence that we've already described to you. Your Honours, in the end, this is the case of the prosecution. Two failing pillars, one narrative, the other evidential, on which it is not possible to build anything solid at all. These two pillars are flawed, without which the prosecution's allegations will be revealed for what they are: unfounded speculation due to poor and inadmissible evidence, and a narrative that has no roots in reality of what actually happened in the Central African Republic at that point of time. These two defective pillars, and you cannot build any kind of demonstration that will allow the prosecution to fulfill its obligation to prove the charges beyond any reasonable doubt, which should naturally and logically lead, at the end of the trial, to the recognition of Mr. Said's innocence and his acquittal. Thank you so much, Your Honour.
Madame le Président, cela conclut les discours d'ouverture de la défense. Nous vous remercions.
The opening statements of the defense. Thank you so much.
Thank you very much, Ms. Nauri. Thank you very much, Mr. Jacobs. This brings us to the end of today's session. As you all received our email, we meet here again on Thursday to start with the first prosecution witness. I suppose that's P0547. Can you confirm that, Madam Prosecutor?
That's correct, Madam President.
Thank you very much. So I'll adjourn this matter till we meet again on Thursday at 9:30 in the morning. The court stands adjourned, please.
All rise, vous vous levez.